Okay, what are the crimes called abandonment of helpless persons and exploitations of minors? They are 1. Abandonment of persons in danger and abandonment of one's victim. That's Article 275. Abandoning a minor, Article 276. Abandonment of minor by person entrusted with his custody, indifference of parents, and exploitation of minors. So let's delve on with Article 275, abandonment of persons in danger and abandonment of one's own victim. The penalty of arresto mayor shall be imposed upon 1. Anyone who shall fail to render assistance to any person whom he shall find in an uninhabited place, wounded or in danger of dying, when he can render such assistance without detriment to himself, unless such omission shall constitute a more serious offense. Number 2, anyone who shall fail to help or render assistance to another whom he has accidentally wounded or injured. And 3, anyone who having found an abandoned child under 7 years of age shall fail to deliver said child to the authorities or to his family, or shall fail to take him to a safe place. Hapit ko na igo, there is experience na ako the last month lang to yata. One Sunday of last month, October, we visited dito sa akong grandparents sa Mungkayo. So along with my better half, so paingon na abot namin ito, and then when we went back, pabalik na sa Davao, so we started about mga pila ka kilometers na to, and siyempre every time na mag-depart sa place, mag-pray man gina, no? So I let my wife pray. And then afterwards, pray me mga several kilometers after, mga 2 o 5 kilometers, so nagkalit lang na ni bangga sa mua, yung kalit lang na ibangga sa mua, and then today sa sakwa, na namin sa highway, di namin sa tunga, the 4 lanes ng highway, no, palit dire, 4 lanes, so namin sa tunga, so namin sa middle nga lane, dito pagapato na sa Davao pa nila dire. And then sa right side na mo, one barangay after our barangay, sa right side na ay downhill nga kalsada pababa dito sa highway, and then wala siya ay crossing, meaning isa lang siya pababaan lang siya, di wala siya go through nga crossing ganit, dili siya moderitso. So what the rider would do is slow down sila, and then right turn na dayon, or kung left turn, slow down sa bago siya mo left turn. And then ang hitabo ay kay wala na siya brake, pababa siya kay stiff kayo ang pababa galing sa kalsada, wala brake, kanit lang nibangga sa harapan pa ginawa nibangga. So kung ikuan yun siya, kung i-check yun by the damages of our vehicle, kami ko nakabangga, pero sila yun ang nibangga sa mo kay wala brake. And then ang naka-ride sa iyahay ato driver, atong asawa niya, pati anak niya nga mga 7 years old pa yata itong anak. Ayun, disgrasya sila. May nalang kay dili kusog among dagan, so skid sila dito, na slide ang ilang sakyanan, pati mo lagpot sila tulo, uyawa na ako, freeze ko. And so we render assistance. Wala ko kabalo ani nga balao dito sa on our mind, palampot inherent sa among mind sa kong misis na ipat diretso sa hospital, tambalan diretso. So gi-assist na mo, then afterwards wala man kayo grabe na bulong sa ilaha, mga gabi na kayo may nakaulo jud, paggabi na nahuman, pagawas sa hospital, and we give them some token, pero kato angkon jud sila nga sila ilang sala kay kuan kanang wadag break. So that happens, no? Nakay justification, syempre unahon jud mo imong sarili, parehas mo sandal, wala dili man na siya inaana nga situation kanang bangga lahi na siya kanang katong situation nga naay nakita nimo nga kung kana sane ka, wala kay samad, nalabyan nimo, nakita nila mo helpless sa kalsada, dapat imo siyang timanon jud nimo. Pero kung na ikaw mismo samdan, discuss siya na wala na kay obligation ana nga padala pa nimo yung sa hospital ang sarili, kay ikaw mismo tabangunon man ka. Is ang guilty ani karon kato mga laing tao nga mulabay sa inyo, ginalabyan lang mo, dili mo padala support, sila ang guilty ani nga na provision. Kung ikaw nakabangga, and then dili ka nabangga at wala kay touch sa, imo pa i-help yun, no? Imo gyud i-help nimo ang katong na victim. Mao siya ang Article 275. The elements that the place is not inhabited, minay ka mingaw ba awaaw gani uninhabited place. So kung inhabited place mo, dili maka anjud nga ikaw ra gyud nga naa didto mo ra gyud kay ikaw jud ang obligado nga motabang sa all the rest magtan-aw lang sa imuha dili man. Mo na ang purpose sa anong gibutang diri sa provision nga not inhabited. Uninhabited meaning walay laing tao, ikaw lang nakaagi, so it's up to you now kung dala sa imong konsensya o labya na nimo di la ka motabang, really up to you. But then again, pag mabalaan ka nga nilabay ka dito, wala ka motabang, you will be liable for this. But ang problema, kinsa mo reklamo. Ay na kaila sa imuha mo reklamo ani. If there are witnesses that find you, what about the witness? Why didn't the witness help the person himself, no? So these are the elements. The accused found there a person wounded or in danger of dying. Another is the accused can render assistance without detriment to himself. Tama to yung ganina, concerning mo is samdan ka, so how would you be able to assist when ikaw na mismo injured, tapos so in doing so would be detrimental to yourself, no? That's an excuse, no? Kung dili ka motabang sa ila. The accused fails to render assistance. And another acts punished under Article 275 is by failing to help or render assistance to another whom the offender has accidentally wounded or injured. Ato among nahitabuan, accidentally wounded or injured, pasok yun mi dito. Wala na mo tagitabangan sila, pwede yun may liable dito during a provision. Even if in the end kabalumi nga dili kami ang sad-an the long run, pero the fact nga amon silang biyaan, wala namang gitabangan. Pero dili man ko tukuan katong lugar nga banggaan namo, dili man to uninhabited, kay daghang kay tao itapukan kay diretso dayon. Then it's actually the barangay that help the victims be brought to the hospital. Sunod lang mi sa kaya kong asawa, nagsunod lang mi sa ilaha. Is the barangay residents dito. And then so siyempre kami na ang kami na nag-assist dito sa hospital, kami na nagbayad sa meron nun. And then pakonsulta sa mga doktor and so on. Pamalunan para magkwarta. Kami sila outside. And the third is by failing to deliver a child under 7 years of age whom the offender has found abandoned to the authorities or to his family, or by failing to take him to a safe place. Remember, the place is uninhabited. So there are 3 situations, ha? Nakitaan kang helpless, in danger of dying, tapos uninhabited na lugar, nakitaan mo, wala nimong gitawangan, or nabanggaan mo, uninhabited lang yapong mga lugar, wala nimong gitabangan, and then ay nakita ni mga bata under 7 years of age, uninhabited nga lugar, wala nimong gitabangan, giabandon lang po nimo, you will be guilty under this particular provision. Article 276, abandoning a minor, the penalty of arresto mayor and a fine not exceeding 500 pesos shall be imposed upon anyone who shall abandon a child under 7 years of age, the custody of which is incumbent upon him. Itong kanina sa 275, dili nimo custody ito, ha, katong bata, nakita, nalabyan na nimo. Kanin, the same child under 7 years of age, pero under your custody, imong giabandona. Okay? When the death of the minor shall result from such abandonment, the culprit shall be punished by prison correctional in its medium and maximum periods. But if the life of the minor shall have been in danger only, the penalty shall be prison correctional in its minimum and medium periods. The provisions contained in the 2 preceding paragraphs shall not prevent the imposition of the penalty provided for the act committed when the same shall constitute a more serious offense. So the elements under 276 are that the offender has the custody of the child, that the child is under 7 years of age, that he abandoned such child, that he has no intent to kill the child when the latter is abandoned. Permanent, conscious, and deliberate abandonment is required in this article. Kinsa po kayo nga guardian mo abandon sa child, no? Kada ko sa konsensya na, tapos biyaan nimo, biyaan lang magay nimo temporarily, tapos pagbalik nimo unsa nagkalandrakaw na ito, di naman gani ma-place sa imong konsensya, disturb ka na kaayo, kana pang i-abandon jud nimo with intention jud deliberately, so for the purpose of leaving the child altogether. There are circumstances qualifying the offense when the death of the minor resulted from such abandonment, or if the life of the minor was in danger because of the abandonment. So, basta kung dako ang imong penalty. Parents guilty of abandoning their children shall be deprived of parental authority. Obviously, hindi na siya, wala na yun ang parental authority sa ilaha. If the offender is the parent of the minor who is abandoned, he shall be deprived of parental authority. What is parental authority, by the way? This is actually when the child is born from the parents, automatic na siya i-grant sa imuha ng parental authority, meaning you are the one who has the right to rear the child, to support the child, and to discipline the child. That's why you have authority over the child, of course. So as the child grows older, you have the right to teach him how to do good, no? All along. That's part of parental authority. So kung to love him, to take care of him, ma-enjoy man mo ang sa child, ang company sa child, even ang agik-ik na nakatawa ang child. So that's part of the parental authority, ma-enjoy sa parents, as well as the obligations, of course. Part sa parental authority is the obligation of the parents to make good the taking care of the child and situate that the welfare of the child is at their utmost thinking all the time, no? When you are taking care of a child, you have to be extra careful on taking care of the child with the end in mind that the welfare of the child is of utmost, no, importance. The welfare of the child. Kung ma-strip ka sa imong parental authority, i-strip ka kay pabayaan mo imong child. So wala na yung kay right sa iyaha nga magdisiplina o matuto sa iyaha. That's deprivation of parental authority. Article 277, abandonment of minor by person entrusted with his custody in difference of parents. The penalty of arresto mayor and a fine not exceeding 500 pesos shall be imposed upon anyone who, having charge of the rearing or education of a minor, shall deliver said minor to a public institution or other persons without the consent of the one who entrusted such child to his care, or in the absence of the latter without the consent of the proper authorities. The same penalty shall be imposed upon the parents who shall neglect their children by not giving them the education which their station in life requires and financial condition permits. So, sagot ani, kung dato ka nga mga ginikanan, imong anak imong ipa-eskwela lang sa public school, kana mga wala kay gasto, ana ba? Wherein maka-afford ka maunta. So, well, you could be penalized under this article. But I had a friend, abogado nga friend, ipa-eskwela nila sa public school ang anak, madato ko na sila. Dili man sila. It's not actually questionable, no, kung asan mo ipa-eskwelahon, for as long as you know nga ang institution, even if public school na siya, is giving good education to the children. Wala may problema na. So how come it is punishable under this? Braka discriminatory na po niya klase ang kuan ba nga balaod. But then again, kung ang kuan mangudri, ang justification mangudri is if ang imo station in life is higher, you should be able to afford sending your children to private schools that you can pay. What if the parents will decide, no, na even if we will not pay, even if we pay the public school, di namo siya pasudlon kay ganahan mi sa education dira. So it scares me on this particular article nga butan nila ang parents kung asa pa eskwelahon, no. That's questionable ni nga. I have reservation in this article na second paragraph. So parents na guna kaning neglect by not giving them the education, kanang dili pa eskwelahon, dili na po na pwede, kanang in-neglect na gyud, dili nimo taga education. Pero kung pa-eskwelahon nimo siya with justification that Really, in all schools, this the public school has given the best education for any children. And tanaw tong mga amigo nga iyang mga anak ipa-eskwela niya sa Magallanes ug sa Magallanes Central Elementary School o diri sa Palma Hill Central Elementary School. Pag-graduate nila karon top na sa silang senior high school, no? Top notcher karon sa Ateneo because of the discipline that they were inculcated sa ilaha sa atong public school pa sila. I admire the parents na doing that, no? Putting into consideration that they are actually thinking about the welfare of their children, even if they are sending their children to public school, even if they can afford private school, so to speak, no? But I really admire the parents. Amigo na ko to, ang abogado. Pag-abogado na tapos sa public, nakogranggo sa gobyerno iyang asawa. Anyway, so Article 277. Let's go to Article 278. Exploitation of minors. The penalty of prison, correctional in its minimum and medium periods, and a fine not exceeding 500 pesos shall be imposed upon any person who shall cause any boy or girl under 16 years of age perform any dangerous feat of balancing, physical strength, or contortion. Any person who being an acrobat, gymnast, rope walker, diver, wild animal tamer, or circus manager, or engaged in a similar calling shall employ in exhibitions of these kinds children under 16 years of age who are not his children or descendants. So, exploitation of minors siya. And then, any kanagaling sa peryahan. O mga gymnast sa peryahan. Mga mag-atto diha sa kalugar, mag-exhibition sila, gymnastics, sa tent, magbayad lang mo dito para makasulod mo. Tanaw mo sa ilang mga acrobatics dito. Pero kung okay lang, kung dili mga minor ang mga children nga na dito, but then kung mga minor na gani, you really have to be careful. Of course, para ma-avoid ni siya nga violation siya, ipa-register nimo ang mga minors in your employ nga nagbuhat ani exhibition, wild animal tamer, walker, diver, circus manager, performing any dangerous feat of balancing, physical strength, or contortion. Ipa-register mo sa Department of Labor, DOLI. Labi na ka ng mga 15 years old, mga minor pa, 15 years old below. Register nimo. And then, of course, ang mga parents po dapat mo pirma po dito sa registration that they give their consent on the employment of such minors. So, number 3, any person engaged in any of the callings enumerated in the next preceding paragraph who shall employ any descendant of his under 12 years of age in such dangerous exhibition. This time, descendant, sa number 2, dili niya children or descendants, pero mga minor, 16 years of age. Number 3, bisag iyang descendant, iyang anak, pero under 12 years of age, delikado na siya, kabayulit na kadari. And then any ascendants, guardian, teacher, or person entrusted in any capacity with the care of a child under 16 years of age, who shall deliver such child gratuitously to any person following any of the callings enumerated in paragraph 2 hereof, or to any habitual vagrant or beggar. If the delivery shall have been made in consideration of any price, murag imo siyang ipatrabaho dito ba? Hala na patrabaho kay murag na abilidad na ako anak nga contortionist, pwede siya mabalik-balik bisa pag magbalik-baliktad ikuliko ni mong tail niya, ulo niya, diligya po maunsa ba kay murag way bukog. So patrabaho na mo sa inyo, pero kung may pag mga edad ni siya, under 16 years of age, liable ang mga parents na nag-deliver ani sila. If the delivery shall have been made in consideration of any price, compensation, or promise, the penalty shall in every case be imposed in its maximum period. So mas taas-taas, no? In either case, the guardian or curator convicted shall also be removed from office as guardian or curator, and in the case of the parents of a child, they may be deprived temporarily or perpetually in the discretion of the court of their parental authority. Any person who shall induce any child under 16 years of age to abandon the home of its ascendants, guardians, curators, or teachers, to follow any person engaged in any of the callings mentioned in paragraph to her of or to accompany any habitual vagrant or vagrant. Remember, ang pinaka-basis nila kining paragraph 2 kaning mga employer nga nag-employ aning acrobatics, gymnast, rope walker, diver, wild animal tamer, or circus manager, or in similar calling. Mo na ang basis sa mga aning nga provisions 278, no? And then the minor is under 16 years of age. So this is called exploitation of minors. Article 279, additional penalties for other offenses. The imposition of the penalties prescribed in the preceding article shall not prevent the imposition upon the same person of the penalty provided for any other felonies defined and punished by this code. Let's go to section 2, trespass to dwelling. Qualified trespass to dwelling. Trespass to dwelling is entering into a home without any permission, without consent by the homeowner. So any private person who shall enter the dwelling of another against the latter's will shall be punished by arresto mayor and a fine not exceeding 1,000 pesos. If the offense be committed by means of violence or intimidation, the penalty shall be prison correctional in its medium and maximum periods and a fine not exceeding 1,000 pesos. The provisions of this article shall not be applicable to any person who shall enter another's dwelling for the purpose of preventing some serious harm to himself, the occupants of the dwelling, or a third person, nor shall it be applicable to any person who shall enter a dwelling for the purpose of rendering some service to humanity or justice, nor to anyone who shall enter cafes, taverns, inns, and other public houses while the same are open. So take note of the elements of the trespass to dwelling, that the offender is a private person, that he enters the dwelling of another, that such entrance is against the latter's will. Except lang kung ang pagsulod is mo ang mga circumstance pagsulod nimo for purposes of preventing some serious harm to himself. So itago siya dito para dili siya masakpan sa nagukod sa iyaha, ano ba? Or to himself or the occupants of the dwelling, na proteksyonan nimo ang occupants or a third person. Nor shall it be applicable to any person who shall enter a dwelling for the purpose of rendering some service to humanity or justice. Sulod ka ito kay sulod ang mga authorities dito para dakpon ang tao nga natago-tago sa sulod kana rendering some service to humanity or justice na siya. Or kung sulod ka cafe, taverns, inns, and other public houses, sulod ka dito, wala pananghin, basta open pa sila, dili ka pwede ma-charge o trespass to dwelling. But if the cafes, taverns, inns, and other public houses are already closed, and you enter into these cafes, taverns, inns, and other public houses without the consent of the person na in charge nga cafes, taverns, inns, and other public houses, then you will be charged, no? Under this article, trespass to dwelling considered. What is dwelling place? Dwelling place, as used in this article, means any building or structure exclusively devoted for rest and comfort, as distinguished from places devoted to business, offices, etc. In the case of People versus Lamahang, 61 Philippines 703, a store of cheap goods, which was also the dwelling place of the owner thereof, was considered a dwelling. The accused was found guilty of attempted trespass to dwelling. Whether a building is a dwelling house or not depends upon the use to which it is put. A barn may be converted into a dwelling house or a dwelling house into a barn by any change of use. Dwelling includes a room when occupied by another person. So sa boarding house man god, na mga room diya, no? So each room is occupied by another person. Each room should be your dwelling. Kung sulod ang isa ka tao dito sa imong kwarto, and then wala parangi, that will be considered as trespass to dwelling. Neither the nature of the crime nor the responsibility of its perpetrator is altered by the fact that the accused was living as a boarder in the same house of which the room of the offended occupant he entered was a part, no? Kauban na po niya, nagsulod siya dito. So trespass to dwelling na. So entrance into dwelling must be against the will of owner or occupant. So note the word against used in the law to distinguish the case from a mere lack of consent of the dweller, because the mere absence of his consent is not enough to constitute the crime of trespass to dwelling. So kailangan na agad siya pagsupak against gila siya, not necessarily without consent, but pagsupak yun, no? To commit trespass, the entrance by the accused should be against the presumed or express prohibition of the occupant, and the lack of permission should not be confused with prohibition. But kung ang balay sirado, nya musulod jud ka, mamugos ka sulod, nya walay tao dito, walay tao sa sulod. Tapos pabuton pa rin mo nga mo kuan mo. Sana musupak tong tag-iya, ay sulod dira. Isulod naman ka, walay tao dito. That's already trespass to dwelling, even if there's no consent given, because the act of locking the house is already not giving permission to anybody who would come in just as easy as that, no? It could be against, no? Dili na siya ingon nga kanang lack of consent lang, no? Lack of permission does not amount to prohibition. It is not necessary in the ordinary life of man in order to call at the door of a house or to enter it to obtain the previous permission from the owner who lives in it. Without most good faith, a person to whom entrance has not been denied beforehand may suppose that the owner of the house has no objection to receiving him in it. Pero kung sirado lagi, lahi na po ng istorya, no? In general, all members of the household must be presumed to have authority to extend an invitation to enter the house. Thus, an invitation to enter a dwelling extended by a girl 12 years old, an inmate thereof, was held sufficient to justify the claim that the entry was not made against the occupant's will, in the absence of express prohibition on his part. Implied prohibition, ha? Tara naman, implied prohibition, ha? So, after all we have discussed about express prohibition, there is implied prohibition. Thus, early in the morning, defendant went up the house of the offended party and entered the room of the latter's daughter, who was then sleeping. There was no lock to the door to prevent the entrance of any person. Here, there is trespass to dwelling. Express prohibition is not necessary because prohibition in this case is presumed. Considering the time, the fact that the door was closed, and the fact that the daughter was sleeping and the offended party was in the market. It is a well-settled rule that whoever enters the dwelling of another at late hour of the night after the inmates have retired and closed their doors does so against their will. Under these circumstances, an express prohibition is not necessary as it is presumed. The fact that the door of the room was only fastened by a string too weak and inadequate to hold it fast does not alter the fact that the offended party wished it to be understood that she did not desire anyone to enter without her express consent. There was implied prohibition to enter a dwelling in a case where the owner thereof had told the defendants to wait in the open porch and then closed the door behind him as he entered the drawing room. Prohibition is implied in entrance through the window. While it is true that the window was open when the defendants passed through it in order to gain entrance into the house, there is an implied prohibition when entrance is made through means not intended for ingress. Prohibition must be in existence prior to or at the time of entrance. The facts or circumstances from which the objection of the occupant may be inferred should be in existence prior to or at the time of the entry. In no event can facts arising after entry has been effected with the express or implied consent of the occupant change the character of the entry from one with consent to one contrary thereto. In this case, the accused entered the house by the principal door, which they found half open. There was no opposition of any kind from the occupant at the time of entrance by the accused. So distinguish this ruling from that of, U.S. versus Arceo. In the case of U.S. versus Arceo, there was violence used by the accused immediately after entrance without the consent of the owner of the house. So there are a lot being mentioned here on trespass to dwelling. So trespass by means of violence, trespass by means of intimidation, hulgaon na, di ko mapasunod doon, pamatat yung taman mo ron. The violence or intimidation may take place immediately after the entrance. Article 281, other forms of trespass. The penalty of arresto minor or a fine not exceeding 200 pesos or both shall be imposed upon any person who shall enter the closed premises or the fenced estate of another while either of them is uninhabited, if the prohibition to enter be manifest and the trespasser has not secured the permission of the owner or the caretaker of. Usually sa mga inaani mga dagkong mga estate, no, nakabutang no trespassing, private property. So kung naay nakabutang ana, nga musulod ka, pwede yung ka liable ani. I remember ko atong bata pa ko, naghami barkada, magsige maglakaw-lakaw, tapos manulod may kalubihan. Tapos pasulod na mo kalubihan, may mga lubi dito nga tagak, ako pang kuhaon, dalahon naman sa balay. Na, intas, other forms of trespass to siya ba, now I realize, pero bata pa man god ko ato. So kung nadakpan niya to, pwede na ko, di mo pwede mapriso kay mga bata pa, minor pa man kaya. Pero akong experience dito is, naman yung mga caretaker na mulang lipaton na namo to. I don't to sa inyo kung ka-experience mo ani. May mga caretaker, lipaton, among grupo, lipat-lipat. Ang caretaker, layo ang caretaker, dagan may pagwao ng mga kontas. Sige, mag-harvest ito, mambuak may butong, ano ba? Ang na mga butong, tapos ang caretaker, kabantay, hey, magdalag pinoti, kukuron mi. Pagkukod na mo, krampas dagan, bata palagi. Krampas dagan, hantod, nagabaan, bitaw. Tumba bitaw ko, naigo akong tiil din sa kuhan, sa kanang yung barbed wire nila, ginakural-kural. Diba, amping ka mo, like, katuwa, yun ako na bantayan, ay, igo akong tiil. Tanawa akong tiil ko sa right foot na ako, sa mga bitiis na ako, atubangan. Naya gini siya yung marka, permanent nga marka, gini na, scar, gini na, permanent. Hindi gina ako malimtaning, makabuha naman sa bata, pahantod ka ron, pero titakuha sa permanent scar. So, it was because of our indiscretion when we were still younger. But kung nadakpan mi ato, kagawa sa gihapon kay mga minors patagimi. Kalingawan lang gud ko mga bata, malingaw-lingaw man na. Pamadlong ba siguro tungod sa curiosity man gud, no? And then the fun when you are with friends, when you're still younger, the fun of doing something even if you may have transgressed to the rights of other property rights of others. But the fun is there, no? Sa bata pa mo. Wala mo kisihuda kung sa iyong magkuhan. Basta kay malipayon mo ato. Bahalag mga disgrasya mo. Nagani one time kanang isa ka sityo, kalaban sa mong sityo, maglabayay big bato dito sa may kuhan. Sa tunga-tunga sa mong boundary, sa may boundary banda. Maglabayay ba to? Pag uli na mo, nagkakay mga bukol-bukol ang mga dugo-dugo ang mga naong. Maigo sa batong gilabay. Pero we were having fun, no, as children. Okay, so the elements under Article 281 are that the offender enters the closed premises or the fenced estate of another, that the entrance is made while either of them is uninhabited, that the prohibition to enter be manifest, that the trespasser has not secured the permission of the owner or the caretaker of. Dami na karang mga mga coconut plantation, sulod ka dito. Actually, kung kato mong ginabuhat, kung dakpon dyan miyato, niya namin sa dili nami mga minors, mga dagko nami, we will be liable for qualified theft ang kwan. Na usually, dako kayo ng piyansa, tag 60,000 ang piyansa, and then nagani ko trial hatod karon pamahuman almost 10 years na or 10 years na gid siguro to. Ang kaso sa mati ginabalik-balikan pa na ako qualified theft because nang-harvest og kanang allegedly nang-harvest og coconut nga dili ilang lupa, dili ilang kalubihan. But sila pa po maingon pa kami may tanong ana gi-harvest na namo charge pa mi qualified theft. Hantod karon gina-trial pa namo. Ang nag-away mga heredero ra pud. Nagkuan sila istorya sila mo na iyang kuan, mo na iyang lugar, mo na po ng lugar. Nagsabot na daw sa asa mga lugar tapos nag-harvest, pag-harvest, amo man gitanom diri. Dili naman na imong lugar. Gani nga mga allegations. So it's now being tried until now. Wala dili ba dayon kay COVID lagi. Antod ang trial na lang kanang online na lang. Anyway, so here are the elements, no? Meaning of premises. Premises signifies distinct and definite locality. It may mean a room, shop, building, or definite area. But in either case, locality is fixed. That's what it means by premises. No? Entering a warehouse may be trespass under this article. This is so because the warehouse is a closed premise, and if it is uninhabited, prohibition is manifest and no permission is given. The entrance into the same is other form of trespass. So as distinguished from trespass to dwelling, in trespass to dwelling, the offender is a private person. In other forms of trespass, the offender is any person. Pwede public person, no? In the first, the offender enters a dwelling house. In the second, the offender enters closed premises or fenced estate. In the first, the place entered is inhabited. In the second, the place entered is uninhabited. In the first, the act constituting the crime is entering the dwelling against the will of the owner. In the second, it is entering the closed premises or the fenced estate without securing the permission of the owner or caretaker thereof. In the first, the prohibition to enter is expressed or implied. In the second, the prohibition to enter must be manifest. Now let's go to threats and coercion. Article 282, grave threats. Any person who shall threaten another with the infliction upon the person, owner, or property of the latter, or of his family, of any wrong amounting to a crime shall suffer. So wrong, hulgaon nimo siya. Imo siyang hulgaon nga patyon, imo siyang hulgaon nga bunalan, imo siya hulgaon nga samdan, imo siya hulgaon nga sunugon, imo siya hulgaon nga tamak-tamakan. Ana, mana mga wrong amounting to a crime, no? Kinsa yung hulgaon, atong person, even owner, no? Owner ani is pakaulawan ta ka sa mga tao ron. Ingnon ta ka sa mga tao nga kawatan, that's owner, no? Or property of the latter. Sunugon ako niyong property. That's a wrong amounting to a crime. So, sa penalty, 1, the penalty is lower in degree than that prescribed by law for the crime he threatened to commit. So, kung nung ako nga, patyunta ka. So, muna, ang grave threats niya, patyunta ka. Ang pagpatay, ang crime ana is di ba, reclusion temporal kay homicide man na. So ang lower nila is prison mayor. Prison correctional, no. Prison mayor day. Ang lower than that is the next lower in degree is prison mayor. Prison correctional mo na ang imong penalty. If the offender shall have made the threat demanding money or imposing any other condition, even though not unlawful, and said offender shall have attained his purpose. If the offender shall not have attained his purpose, the penalty lower by 2 degrees shall be imposed. So 2 degrees na this time. So from prison correction, so reclusion temporal, ang 1 degree lower is prison mayor, 2 degrees lower is prison correctional. So muna ang mabutang diri, no, sa second paragraph. If the threat be made in writing or through a first paragraph, or through a middleman, the penalty shall be imposed in its maximum period. The penalty for resto mayor and a fine not exceeding 500 pesos if the threat shall not have been made subject to a condition. Resto mayor na lang, no? Acts punishable as grave threat that by threatening another with the infliction upon his person, owner, or property, or that of his family, any wrong amounting to a crime, and demanding money or imposing any other condition, even though not unlawful, and the offender attain his purpose. By making such threat without the offender attaining his purpose, by threatening another with the infliction upon his person, owner, or property, or that of his family of any wrong amounting to a crime, the threat not being subject to a condition. Basta na-threat lang siya, magtay ka. Suppose A threatened B that unless the latter send him 1,000 pesos, he would kidnap his son. Would it be grave threats considering that the wrong threatened to be inflicted would amount to a crime against liberty? It is believed that the crime committed is grave threats. Such a threat affects a person of a member of the family of the offended party, and kidnapping is an act amounting to a crime. Another example, threat to commit a crime upon a person of the offended party. A sent a letter to B in which A said that unless B would send him 1,000 pesos, A would kill B. B sent 1,000 pesos to A. The threat to kill B involves a crime against the person of B, which is homicide. Okay? Threats to commit a crime upon the property of the offended party. So, property na po. A sent C to B to tell, as in fact he told the latter that if he would not send 1,000 pesos, A would burn B's house. B sent the money to A. The threat to burn the house of B involves a crime against his property, which is arson. Threats to commit a crime upon the owner of the offended party. A told B that unless the latter would give him 1,000 pesos, he would place inside his house a tin of opium, and then he would report the matter to the police. B sent 1,000 pesos to A. The threat involves the crime of incriminating an innocent person. But threatening to publish a libel and offering to prevent such publication for money is punished under Article 356, not under Article 282. I think this Article 356 is ginatawag nila blackmail. Blackmailing siya under Article 356. Demand for money. Note that in examples above, there is a demand for money. In the case, the accused sent a letter to an old woman threatening her with death or the burning of her house unless she gave him 500 pesos, which she must deposit in the place indicated to her in the letter. When arrested and searched, the accused had in his pocketbook an envelope in which was written the name of the offended party. It was held that the accused was guilty of grave threats. Okay, let's proceed with another article. Just read all the other examples there. Article 283, light threats. A threat to commit a wrong not constituting a crime made in the manner expressed in subdivision 1 of the next preceding article shall be punished by arresto mayor. So arresto mayor na siya, punishment ani na, sa element ani, that offender makes a threat to commit a wrong, that the wrong does not constitute a crime, that there is a demand for money or that other condition is imposed even though not unlawful, that the offender has attained his purpose or that he has not attained his purpose. Light threats are committed in the same manner as grave threats, except that the act threatened to be committed should not be a crime. So note that light threat is committed in a manner expressed in subdivision 1 of the next preceding article, except that wrong threatened threatened to be committed does not constitute a crime. Sa may example ani, when A threatens B with exposure without demand for money or other condition, Article 283 does not apply. When orally made, Article 285 paragraph 3 applies because this provision requires no imposition of condition or demand for money. Blackmailing may be punished under Article 283. Light threats may amount to blackmailing. Example, A threatens B with accusation or exposure. If B does not give 1,000 pesos to be deposited at an indicated place. Within this provision would fall many cases of blackmailing, that is, the unlawful extortion of money by an appeal to the fear of the victim or by threats of accusation or exposure. Sample of light threats. But according to the court, Shahu together with his co-accused committed another crime, that of light threats, contrary to a contention of his counsel that no crime was committed by him. As the threat made by the accused that they would report the offended party to the authorities did not constitute a crime, i-report lang man, the crime committed by them when they made the threat demanding money was only light threats, defined and penalized under Article 283 of the Revised Penal Code. Article 284, banned for good behavior. In all cases falling within the two next preceding articles, the person making 282, 283 sabot sa within the two next preceding articles. So 283 and then 282. In all cases falling within the two next preceding articles, the person making the threats may also be required to give bail not to molest the person threatened, or if he shall fail to give such bail, he shall be sentenced to dischero. That is banned for good behavior. Prevent lang dili siya i-molest, no? The giving of bail is an additional penalty. In other words, may also be required in this article, indicating that it is an additional penalty other than katong dischero good. Kato sa Article 35 man good, banned to keep the peace man ito. Kani siya banned for good behavior. Article 285, other light threats. Light threats man to, no? Ganina sa 284, kani other light threats. The penalty of arresto minor, its minimum period or a fine not exceeding 200 pesos shall be imposed upon any person who, without being included in the provision of the next preceding article, shall threaten another with a weapon or draw such weapon in a quarrel unless it be in lawful self-defense. Iya lang, sige, ako ni hulbuton na karon akong sundang. Any person who in the heat of anger shall orally threaten another with some harm not constituting a crime, and who by subsequent acts shows that he did not persist in the idea involved in his threat, provided that the circumstances of the offense shall not bring it within the provision of Article 282 of this code. Any person who shall orally threaten to do another any harm not constituting a felony. Hard ni kayo nga situation, no? At you are you are saying to, you are threatening a person to do any harm, pero ang imong harm nga ibuhat sa iya dili constituting felony. Seldom, scarce, no, very very seldom mahitabo. Ang pinaka-example lang nato nga na kitaan before sa atong explanation a while ago is that i-report ka sa authority, ana. I-report ka or expose ka, tukanta ka sa mga tao, ana. Mula na ang act to do harm to that person, but this doing something is not constituting a crime or felony. So these are the elements, no? By threatening another with a weapon or by drawing such weapon in a quarrel unless it be in lawful self-defense. Anang i-draw nimo ang weapon, imong hulboton sa imong saguban, sa hinagiban sa tawag ana sa gubang, kuhaon nimo imong sundang sa iyang saklob, that's drawing a weapon by orally threatening another in heat of anger with some harm that constitutes a crime without persisting in the idea involved in this threat. Note the word not in this paragraph is enclosed in parentheses because the inclusion of that word in paragraph 2 of article 285 is a mistake. By orally threatening to do another any harm not constituting a felony. Orally threatening another in the heat of anger with some harm. In English, a person who in the heat of anger threatened to kill another without persisting in the idea involved in his threat is liable under paragraph 2 of article 285. Threats which ordinarily are grave threats if made in the heat of anger may be other light threats, no? The accused who threatens another especially and expressly with the infliction upon the latter's person of a wrong amounting to a crime, I will shoot you, imposing a condition therefore, if you will not leave the place, is ordinarily guilty of the crime of grave threats under Article 282 of the Revised Penal Code, where however the accused had flung the threat in a sudden flare of anger following the offended party's initial disregard of his command to leave the place, which the offended party had mistaken for a joke. The crime committed is only other light threats under Article 285 of the same code. Can other light threats be committed where the person to whom it is directed is absent? Yes. Where the threats are directed to a person who is absent and uttered in a temporary fit of anger, the offense is only light threats. Now let's go to grave coercions. So the penalty of prison correctional and a fine not exceeding 6,000 pesos shall be imposed upon any person who without authority of law shall by means of violence, threats, or intimidation prevent another from doing something not prohibited by law or compel him to do something against his will, whether it be right or wrong. So imong gipugos nga pabuhaton or imong gipugos nga dili buhaton ang iyang ginabuhat nga dili in violation sa balaod, mana ang element niya. If the coercion be committed in violation of the exercise of the right of suffrage, mubuto na siya, imo siyang gipagipugnan, or for the purpose of compelling another to perform any religious act or to prevent him from exercising such right or from so doing such act, the penalty next higher in degree shall be imposed. So muna ang grave coercion tawag. So grave coercion ang tana. Ang central point lang sa grave coercion is that the person prevented another from doing something not prohibited by law or that he compelled him to do something against his will, be it right or wrong. And another one, that the prevention or compulsion be effected by violence, threats, or intimidation. That the person restrained the will and liberty of another had not the authority of law or the right to do so. Or in other words, that the restraint shall not be made under authority of law or in the exercise of any lawful right. So, coercion by preventing. So, A was harvesting palay on a disputed piece of land, B claiming to have a right to the property. By means of violence, prevented A from harvesting the palay. That's coercion by preventing. What is prevented must not be prohibited by law. The phrase not prohibited by law in the first paragraph of Article 286. The thing prevented from execution must not be prohibited by law. Otherwise, there will be no coercion. Thus, no coercion is committed by one who prevents a murderer from carrying out his wicked purpose. In grave coercion, the act of preventing by force must be made at the time the offended party was doing or about to do the act to be prevented. If the act was already done when violence is exerted, the crime is unjust vexation. Human naman, no? Wala naman siya i-prevent, kana humanan niya eh. A person who takes the law into his hands with violence is guilty of grave coercion. Thus, forcibly ejecting an occupant from the land both by the offender without authority from the court is coercion. Also, forcibly invading the land, claiming to be the owner thereof, and taking the palay and kamote harvested therefrom by the occupant is coercion. Article 287, light coercions. Any person who by means of violence shall seize anything belonging to his debtor for the purpose of applying the same to the payment of the debt shall suffer the penalty of arresto mayor in its minimum period and a fine equivalent to the value of the thing, but in no case less than 75 pesos. So, ikaw pa'y nautangan, ikaw pa'y makabayad ayon sa ilaha. Nga naman, pugos man mo. So, dapat file lang yung kaso sa korte, pabarangay ka na nakautang sa imo, ayaw yung pangbirahan ng mga butang niya dito, no? Any other coercion or unjust vexation shall be punished by arresto mayor or a fine ranging from 5 to 200 pesos or both. So, walay kumog yun nga cool head lang kita permi when we are confronted with any situations that make us angry. Dapat kontrolado yun mo yung anger, no? Para di ka madisgrasya, no? So again, light coercion is by means of violence shall seize anything belonging to his debtor for the purpose of applying the same to the payment of the debt. So the elements that the offender must be a creditor, that he seizes anything belonging to his debtor, that the seizure of the thing be accomplished by means of violence or a display of material force producing intimidation, and that the purpose of the offender is to apply the same to the payment of the debt. Unless mayroon ang debtor ko, welcome to my house, take anything you want, and then I'm sure pagka humaana, I'm already paid, ha? Wala problema na. Pero kung diretso lang kasunod, dala ka mga goons diya, tapos stand na mo, pagbirahon ni mo salaset sa imo ang giutangan ni mo, ang television set, pagbirahon ni mo, stereo, birahon ni mo. Sila, isa ka pungong kay naman kay mga dalanggons, basi pugmukuan sila, basi ma-disgrasya pa sila. So, ana ang light coercions. Other similar coercions, compulsory for purchase of merchandise and payment of wages by means of tokens. So, kung mabayad ka ng sweldo, dapat kwarta yun yung mabayad. Ayaw tokens, ayaw ng mga bugas, ayaw ng mga kwarta yun. Kung pilay sweldo niya, mo yun ito ibayad mo, no? The penalty of arresto mayor or fine ranging from 200 to 500 pesos or both shall be imposed upon any person, agent, or officer, or any association or corporation who shall force or compel directly or indirectly, or shall knowingly permit any laborer or employee employed by him or by such firm or corporation to be forced or compelled to purchase merchandise or commodities of any kind. So, dire mo pamalit sa mga ayaw sa gawas. The same penalty shall be imposed upon any person who shall pay the wages due to the laborer or employee employed by him by means of tokens or objects other than the legal tender currency of the Philippine Islands unless expressly requested by the laborer or employee. So kung dili sila mag-request, ang ibayad yun mo sa ila kwarta yun, no? Dili ng kindi, dili ng bula, dili ng bugas, dili ng tinapa. Basta kwarta yung ibayad, pilay mong bayron siya, kwarta yun yung bayad. So that's other similar coercions. Formation, maintenance, and prohibition of combination of capital or labor through violence or threats. The penalty of arresto mayor and a fine not exceeding 300 pesos shall be imposed upon any persons who for the purpose of organizing, maintaining, or preventing coalition of capital or labor, strike or laborers, or lockout of employers shall employ violence or threats in such a degree as to compel or force the laborers or employers in the free and legal exercise of their industrial work, if the act shall not constitute a more serious offense in accordance with the provision of this code. One of mga elements that the offender employs violence or threats in such a degree as to compel or force the laborers or employers in the free and legal exercise of their industry or work. That the purpose is to organize, maintain, or prevent coalitions of capital or labor, strike of laborers, or lockout of employers. Bawal ni siya. Ano mga police gani, kada mga guns, bawal kung na mag-strike diya sa premises sa company, dapat layo na sila, dili na sila mapaduol dito, no? Kaya otherwise, they will be liable for this article 289. Labi na kung apil-apil na sila dito, may labot mga polis ang trabaho sa labor, mag-picket, no? Peaceful picketing, not prohibited, is a part of freedom of speech and therefore cannot be prohibited. Picketing in a peaceful and orderly manner is absolutely legal. It cannot be prohibited for it is part and parcel of the freedom of speech granted by the Constitution. So employing violence or making threat by picketers may make them liable for coercion. Sila mismo na picket, na violent, niya na threat, na threatened, di kaya mo join rin, bantay lang mo. The acts of the picketers in stopping a truck emerging from the company's premises, the refusal to allow its driver to proceed peacefully on his way, their voice threat that if he would go on his way, he would be hurt, or all this notwithstanding the fact that the truck did not belong to the company but to a private individual, are clearly constitutive of the crime of coercion. The picketers' act of remaining in the passageway when the trucks of the company were going inside its premises is not part of the picketing protected by law. The right to picket should be confined strictly and in good faith to gaining information and to peaceful persuasion and argument. Assuming that the laborer's cause is right and legal, reforms in the management of the affairs of the union could be effected by taking the proper remedies through legal processes and not by resorting to coercion and intimidation. Problema man sa legal processes kay dugay kayo. So, uban mag-shortcut na lang para dali lang i-effect, no? The part of the company, kung para dugay pa man ikasuhan to, pratratan na nato ni. So, karampa, wala nang picket na, no? On the part of the picketers, para masira yun ang operation sa company, pampugna na to, babaga na ito yung mga sakyanan. So, lahat po na, shortcut po na sila nga pamahagi, no? But, as I said, going to the legal way is very long and tedious and so expensive, no? In the long run. Kaya, there's a tendency for everybody to go into shortcut. So, what can you do? What can we do? That's the legal processes, no? In the Philippines, diligid siya madali. Preventing employee from joining in the registered labor organization is punished under Labor Code, not under Revised Penal Code. Unfair labor practice shall be punished by a fine at least than 1,000 pesos. Under sa Labor Code, no more than 10,000 pesos, or imprisonment of not less than 3 months, no more than 3 years, or both such fine and imprisonment at the discretion of the court.